All right, everybody, we're going to go ahead and get started. Welcome and thank you so much for coming today to this workshop, Leveraging the Law for Health and the Environment. We have a stellar panel here today full of people that have worked very closely with our organization and very closely on issues that our organization focuses on. And without any further ado, I am so excited to introduce our panel. First up today, we have Amy Van Son, who is a legal fellow at the Center for Food Safety in the Portland, Oregon office. She started as an attorney there in 2015 following practice in New York, which focused on complex environmental insurance litigation. And as part of CFS's legal team, she works on CFS's active docket of impact litigation and high-profile cases on issues related to pollinators, pesticides, organics, genetic engineering, and food labeling. So that is Amy. And after Amy, we'll hear from Rosemary Bilchak, who comes to us from Colorado and actually has, we're kind of giving you a wide range. So we have a couple lawyers, but then we also have someone who's been very successful in winning a lawsuit based on some pesticide trespassing that occurred on her property. And she's going to tell you the story of her and her husband and what they went through and how they successfully navigated the legal system to win and employ really positive, good change that's still waiting to hopefully will help the next person down the line and help change policies as we go forward. So she did some really incredible work that we're excited for you guys to hear about. Then we have here Kim Richman of the Richman Law Group. And he is an accomplished trial attorney in both state and federal courts. His cases address law and policy issues ranging from public health and sustainability to protecting animal rights and civil liberties. Most recently, Mr. Richman is targeting pesticides, including neonicotinoids, in everyday consumer products such as oatmeal and applesauce and granola and all sorts of things. So he's going to tell you about how he is using the law and consumer protection to try to drive market change in a direction that keeps people safe. And then last but not least, we have Paula Dinerstein, who is one of our board members and is also senior counsel for Public Employees for Environmental Responsibility, or PEER. Paula has done a lot of work leading up to her role at PEER. She clerked at a federal district court. And her work has also, in the private sector, has included representation of states and advocacy groups in energy and environmental matters, including cases to ban organochlorine insecticide, chloridane, toxic wood preservatives. She's also successfully sued Fish and Wildlife Service to stop planting genetically engineered crops in National Wildlife Refuge, and she's served on our board of directors. So we're really excited to hear from her as well. We're going to go ahead and get started. Each speaker is going to give a little, presentation, and then at the end, we'll open it up for questions. So I am going to turn it over.
Well, I'm Rosemary Bilchak. I'm an organic farmer from Hotchkiss, Colorado. We're going to take what she was talking about and really focus down on one simple case. So my question is pesticide drift trespass? The answer is yes. What you see there is a fogging event that happened in July of 2010. Everything under that fog is our property. The fog is emanating from a truck that's over on the neighbor's property that you can't see, that's behind our shed. And the density of the fog is something you might want to take a note of, because behind that fog there are two houses that you can't even see. So we called the Department of Agriculture to come out and do testing. They subsequently found more malathion on our property than on the neighbor's property. He was the target property for his mosquitoes. We had respiratory problems and had to vacate our home. Okay, I'm sorry, which one am I pushing? Okay. Well, why we care about pesticides? Well, my husband has a very rare form of leukemia, for starters. He's registered pesticide sensitive with the Department of Agriculture, and he has been told by his oncologist to avoid exposure. Right? We expected to raise our own organic food. We're kind of fanatical about what we put into our bodies. We desired organic certification so that we could then sell our produce to the public. I know my husband is very special to me. However, I really believe that everybody has a right to be free of pesticides, including yours and including mine. And finally, this is a private property rights issue. This came up in one of the previous seminars where somebody talked about you have a right to do on your property what you want to do and to keep somebody else's pesticides off of that property. We live in a place called the North Fork Valley. It consists of 3 small communities. In the 3 towns, there's approximately 4,500 people, all told. Prior to 2008, there was a weekly spraying program for mosquitoes with malathion. And the result was, of course, pesticide-resistant mosquitoes. We also had the highest per capita incidence of West Nile virus in the state. Now, the numbers are going to floor you. Your chances of getting West Nile virus in the area under the jurisdiction of this spray program was 1 in 113. The next highest was 1 in over 5,000. And that was, it's an order of magnitude more. So anyway, there were several of us who were decided that we were determined to stop this rampant spraying. We formed the first political action committee, in Delta County. We publicized who could vote. We used those monies to reach out because the district boundaries don't coincide with anything like a precinct, so we needed to make sure that there were people who had been turned away from the polls previously at previous elections because they were renters. Well, they're allowed to vote if they live in the district. There are people who live in Denver who own property in this area. They're allowed to vote. So it's a screwy set of rules. We made sure people knew about that. But I think the most important thing that we did was that we made sure that people knew to ask for a provisional ballot if they were turned away at the ballot box. And that's a very important part because the result of the election was a tie. And it came down to provisional ballots, and we won by 9 votes. Right, so after the election, we reduced the spraying by implementing an integrated pest management program. We started mapping mosquito breeding sites, we treated the larvae, and we had a huge reduction in the incidences of West Nile virus. Well, of course, not everybody's happy with this result. This is our neighbor's truck. And you can see the fogger in the back and the fog going off kind of to the left. If on the right-hand side of the screen, there is sort of a yellowish line. That's kind of the end of our property. I think can I go over there with the thing? Okay. So the end of our property is over here. This is an access road through our property. We own everything to the left of that all the way around to the south side of his house. So you can see the preponderance of the pesticide is coming onto our property. Well, we talked to the Department of Agriculture. They came out and took samples, but they told us that the investigation would go on for approximately a year. Meanwhile, he's fogging weekly, and we're dealing with this every week. He was not ignorant of our needs. We had gone over multiple times to explain not only our desire to be organic, but Gordon's, my husband's, medical condition. We asked a mutual friend to come over and talk to him and try to get him to stop it. We hired a mediator to go over, and he came back with his tail between his legs because he thought he was really a pretty good mediator. And he said, this man is never going to stop spraying. And finally, we hired a lawyer to write a letter that was kind of charged that says, you need to stop. These people are really serious about protecting their health and their property. Well, some of his statements, Hopper is the defendant, are very illustrative of his attitude. He first of all said that he is protecting his family. Now this comes from the fact that his wife in 2006 had gotten a very severe case of West Nile virus. Well, at that time, the mosquito district was fogging not only all the way around the community, but they were friends of his, so they came up to his house and fogged all the way around his house every week. All right, he uses this incident of West Nile and his fear of West Nile, but he fails to connect the dots that she got West Nile regardless of the fact they were being fogged weekly. And in fact, the opposite is true. It has been shown that fogging gives people a false sense of security and that they take fewer personal precautions, and as a result, there's more incidence of West Nile in communities that are fogged. So I went over and I tried to explain to him about the statistics, the 1 in 113 that I gave you earlier. And at that point, he said, I don't believe it. So I said, here are the numbers. It's just math. At which point he said, I don't believe in math. These are my friends. After I picked up my jaw from the ground, I responded something like, this is like changing your religion, isn't it? And he said, yeah, basically. So organic means eating bugs and worms. That was something he said in court. So much for our desire to be organic. And finally, at his deposition, our attorney asked him if he would continue fogging, even if he knew beforehand that his actions would result in my husband's death. And he said, yes, what difference would it make? Okay. A little emotional. So we filed a complaint in district court in August of 2010 alleging trespass. The Department of Ag actually issued a cease and desist order in April of 2011. They found that he had sprayed a non-target area, he did not have a license, he did not calibrate the machine, had an inappropriate flow rate, and did not even possess a label. And as people have alluded to throughout this conference, this last item is very serious because the label is the law, and you need to not only have it, you need to read it, and you need to abide by it. So the cease and desist order was issued, but his defense attorneys, paid for by the insurance company, went down to the Department of Ag and pounded some tables, and they pressured CDA to issue a watered-down cease and desist order. The CDA also subsequently allowed Hopper to receive a license for the machine he was using, which was ironically called a Category 110 Public Health Applicator's License. We objected to it, but this license was issued anyway. We appealed to the court at that point for a temporary restraining order, which was granted, which protected us for a couple of months. We lost that protection when we lost our bid for a preliminary injunction a couple of months later, and then he went out that weekend and sprayed. Oh, I forgot to tell you too, when we had the lawyer write the letter that said you must stop this spraying, he fogged that night. Just going to tell us. All right, so in July of 2012, we were granted a permanent injunction order. The judge agreed with us that pesticide drift is trespass in and of itself. And this is a very important part because most of the time they had, up until that time, they had to prove damages. Now, we thought it was a fair and rational judgment because it allowed him to continue to fog his property. It just said you can't fog your neighbors. And it set a 150-foot setback from the boundary between the two properties, and it set a requirement that he observe wind speed and direction so as to avoid contamination of our property. That's specified in that permanent injunction order. Well, after the order, we're pretty happy. He continues to fog weekly. You would think that would be the end of it, but no. What we found is that the order just taught him to be trickier. Okay. And so he's fogging at night. No notice is given. When we requested notice, his attorneys wrote us a letter saying that no notice would be given because then we could go out there and watch him. Now, if he's doing everything correctly, why is that a problem? And we suspect, not only do we suspect that there's ongoing contamination, the Department of Ag comes out and proves it. So CDA doesn't do its job in the sense that they found contamination of our property multiple times, but they state it does not constitute the use of this pesticide in an unsafe manner. And on the other hand, these are the certifying agencies for Colorado, and we get a letter that says that we cannot be certified organic because of this very same pesticide. So we had hoped that the CDA would do its job, but year after year they ignored flagrant violations of the label and allow Hopper to continue to hold this license. Well, in August of 2014, I heard the fogger and I thought, boy, that sounds loud. So I opened up my back door, and that's what I saw, which is the same picture you saw, which I took actually in 2010. The only reason I didn't take it in 2014 because I didn't have my camera on hand right there. And by the time I went back in the house, got it, and came around, he had driven around the other side of his house. So for 4 years, the only thing this man has learned is that he can continue to fog our property without consequence. We called CDA, the contamination is proven yet again, and the investigation is still not complete. This is 2017. So because without enforcement the injunction is meaningless, we filed contempt of court. Now, in 2015, he's found guilty of 1 count of contempt of court. In 2016, he's sentenced to jail and fine. Now, it's only 2 days in jail, but it's it. They wait till the end of the time period, and they appeal. Now, this is a good place to emphasize that he is not paying his own bills. We incurred the cost of taking him to court for this contempt of court. He was originally defended by the insurance company, but we suspect that there are bigger players involved at this point. There's no way to get that information. The idea behind an insurance company defense is that their idea is to grind you down. They will continue to incur costs and make sure that they delay everything. You can see the filing of contempt of court in 2014 took until this February for the appeals court to actually make a decision. So what's next is I want to go back to the mediator's statement that he will never stop. We suspect that he will serve his jail time, if he even does, because that's now under contest. Pay his fine, but he will go out and be fogging this summer. The license that is issued by CDA allows this travesty to continue. All right, this license is usually reserved for trained public health professionals, not for people who have, I'm going to read these, failed the test multiple times, violated the label multiple times, stated under oath that if the result of his spraying was someone's death, that was perfectly okay, has been found in contempt of court for violating a permanent injunction order that was specifically crafted to rein in his renegade spraying, and has been sent to jail and fined for this offense. Yet to this day, he holds that license. So what we're doing is we are trying to get the CDA to revoke his license. Last year, in May, we had our lawyer write a letter outlining the rationale, taking the statutes, okay, and citing each of the statutes and then putting the documentation behind it. The letter was approximately 100 pages long. We got no response. So in February, after the appeals decision, I wrote a letter again, citing the first letter and saying, and now we have the affirmation from the appellate court, and they have not responded at all. Okay, I'm almost done here. We've lived through 6.5 years of hell. We've been fogged weekly each summer. We've been footing our bills, and like I said, the grinding down technique. There were over 120 pleadings just during the injunction phase. I haven't counted them since. They have done things like appeal to the Colorado Supreme Court, as well as the appellate court. The invasion of privacy is amazing. You self-impose the social isolation because we are in a small community, and we didn't know until the very end whether or not this was going to be a jury trial, and we didn't want to contaminate the jury. There's the requisite sleepless nights and, of course, the threatening phone calls. So what's the point in this? The point is that precedent has been set. Pesticide drift is trespass. Now, this only applies right now to one district in Colorado, and I'm begging you all to take it, use it, expand it, and make sure that if you don't use it, our effort was in vain, but please take it and try to get it expanded so people know about it. And I have one other which has my information and the case number, Delta District Court 10 CV 220. That's my contact information and our attorneys.
Thank you, Rosemary. All right, now we have Kim Richman.
Amy, can you show me how to get to my slides?
I think I actually opened your presentation.
Good afternoon, everyone. My name is Kim. I'm coming from Brooklyn, New York. I am what you regard as a Robin Hood lawyer. I've also been regarded by the Chamber of Commerce and other conservative front groups as part of the food mafia. And my father-in-law regards me as Peter Pan. I am traditionally a consumer protection class action attorney. A lot of the work that I do is revolving around false and deceptive advertising statutes. State consumer protection advertising statutes. We use that in a very creative fashion as a policy tool. One of the first cases that I brought was over a decade ago against Wendy's, fast food establishment, that purported to be 0 grams of trans fat. Turns out that they had a lot of trans fat in their fries and fried chicken products. So we used basic consumer protection law to say that's an affirmative misrepresentation, and ultimately we prevailed, and Wendy's was compelled to remove trans fat from their products, subject themselves to independent monitoring, and donate over $1 million to various nonprofits. It was a success. It was one of the early food cases. Since then, there have been a proliferation of these food cases, largely in the Northern District of California, and the San Francisco Federal Court, in fact, has now been regarded unofficially as the food court. And from this case, other than the hundreds of other cases that it spawned, which were often not necessarily addressing larger public health issues as we were doing, but on other hyper-technical issues, it's nevertheless developed a body of law that we then further use to address GMOs. And so there was a case that many of you may have heard about involving Wesson oil, manufactured by Conagra. And that spawned even more litigation in the GMO context. And we had gone after a whole variety of companies that purported to be all natural. And that, again, is our hook, because that was false and deceptive advertising according to our consumer base. And we were successful in many of the litigation to remove GMOs from the product. And in some respects, it was far more effective than a lot of the state initiatives, unfortunately. And of course, now we have the DARK Act. So it is using litigation as a policy tool. I am very much of the mind that early on that the government is broken more than ever now, and that litigation can indeed be a policy tool, that what fails by way of legislation can be achieved by way of litigation. The arc of the cases continued to evolve as consumer expectation and consciousness started to rise. And so we started to address a variety of cases involving synthetic ingredients, and then ultimately have been focusing on Roundup and glyphosate. And I'll discuss the arc of those cases and beyond. So one of the first cases that we brought involving glyphosate was against Quaker Oats. And so it came to our attention through various NGOs, through our labs, that, believe it or not, Quaker Oats contains levels of glyphosate. And the reason being, as we've learned, is not because of using glyphosate as a weed killer, but for purposes of using it as a desiccant. In other words, they use it, they spray it right before harvest to make the harvest ready. That there may be a couple patches that are green and they want to rush it to market. And so they'll spray it right before harvest. And that is the reason why we see levels of glyphosate in both oats and wheat, where it's being used as a glyphosate. It's just to maximize profit, not to kill weeds. And so the narrative that we've been trying to develop through litigation is to bring further attention to the fact that, as we all know in this room, glyphosate is in all corners of our food systems, whether it be oats, wheat. We have also since learned it's in honey, and we have also recently detected it in tea. And we know that it's unfortunately in other products through the work of other NGOs. We also have learned that if we were to test 90% of the population, they would also detect levels of glyphosate in their urine. The Quaker Oats case was the first. We have, in fact, filed it in the 4 corners of the country. They ultimately got consolidated in Chicago Federal Court. The same with Nature Valley. And Nature Valley is interesting in that we filed in multiple courts. And believe it or not, it's here in St. Paul Federal Court pending right now on a motion to dismiss, and we'll have oral argument later this month or on May 25th. Nature Valley is interesting in that the arc then started to develop beyond just consumers. And we, as you can see, started bringing cases on behalf of not only consumers, activists, moms, but now nonprofits. And so there has been an interesting development in the law with regards to nonprofit standing. And we'll talk about that further in just a moment. But I started to realize that the litigation alone would perhaps just be within the confines of the court, but because of certain journalists who have picked up on this, it started to go viral. And we had New York Times cover the article, and other organizations, Bloomberg, et cetera. The Quaker Oats case truly did go viral as a result of the New York Times article. It's a very interesting story, and it's, I think, perhaps a good case study in terms of how it can be an effective tool, policy tool. So it got picked up by a whole variety of outlets once the Times reported upon it, and social media went nuts, and they started to do a variety of different, my favorite is Trust Me, It's Healthy, and you have the Quaker Oats man with the Pinocchio nose, et cetera. It got picked up by the Daily Mail, and it also got picked up by the country of Taiwan, who apparently bans any level of glyphosate in their food systems. And as a result of that, they did their own independent testing of Quaker Oats and other oatmeal products, and ultimately banned Quaker Oats altogether. And so if you focus, for instance, here, it says Taiwan's FDA recalls 10 oatmeal products for glyphosate contamination. And so the case is still pending in Chicago Federal. It's awaiting decision on a motion to dismiss, but already has had tremendous impact worldwide. So, as we all know in this room, but that glyphosate is perhaps the tip of the iceberg, and that there are a whole host of other pesticides that are adulterating our food systems, from neonicotinoids to atrazine to antibiotics. And so the litigation has evolved accordingly, and we are using that body of law, that all-natural body of law, or products that perhaps purport to be pure or healthy to some extent, is our hook. It's our way of getting into the product. It's a way of putting pressure upon, in essence, Monsanto's consumers or customers, namely the Quaker Oats and the General Mills of the world. And it is beautiful in that, especially with the, these cases that are on behalf of nationwide classes and the general public, that with the consumer protection cases, one person can be the voice of millions. That the law is such that when it comes to consumer protection, we don't need to necessarily sign up each and every person. And so as a former community organizer trying to get a critical mass of people to show up to a protest or an event, this was a very effective way where just one mom, for instance, can step forward and be the voice of moms across America. Same for, with regards to these nonprofit actions, which I'll talk further about in just a moment. And so here we see a proliferation of cases that my firm has brought involving a whole host of products. Many of you may be familiar with Natural American Spirit. It's a cigarette product that purports to be all natural, additive free. It has been tagged by AGs, by the FTC, by the FDA for basically suggesting that its product is healthier and safer than other cigarette products. And it has taken a number of consumer protection actions, as well as an action that I brought on behalf of a nonprofit based in DC called Breathe DC, in order to put more pressure and to basically enforce what the government has failed to enforce. We have also seen just the proliferation of pesticides, not only in processed foods, but also in meat products, and have been addressing that in a case that we brought in D.C. On behalf of the Animal Legal Defense Fund against Hormel, who's the manufacturer of Spam. What we have been effectively able to do is put these companies under a microscope in a variety of ways. And so FOIA requests have been very powerful in terms of unearthing information that the government has gathered. We've also have had to do just basic investigatory work in terms of looking at supply chains, talking with experts in the field, and piecing it all together. But one of the most powerful tools that we have found are working with a variety of labs where we, at this point in time, can detect whether it be GMOs, now glyphosate, and other pesticides. And talk about, Exhibit A, where when we file the complaint, without seeking any discovery, issuing any subpoenas, we know precisely what is in their product. And that has been extremely powerful in terms of a lot of these cases where we're able to work with labs such as HRI, which regards itself as a people's lab. And it is a powerful, powerful tool. And so it does take a village, as we have learned over these past couple of days. And it has been the result of coordinating with a number of NGOs and the like in terms of putting a lot of these cases together. And so most recently, the DC Consumer Protection Statute has been amended to give nonprofits broad standing. And so we have been able to represent a whole variety of nonprofits, from ALDF to Beyond Pesticides to OCA, on behalf of the general public. And it's fairly new. The law is still being developed in DC, but we have been seeing some early success. We also find that in bringing these cases in conjunction with the larger consumer protection cases, it puts an exorbitant amount of pressure upon corporate America. So we have talked a lot. It started off with Ronnie Cummings talking about various NGOs pulling together. And it is a question I often ask myself of why are we not more united? And I hope that, because of conferences like this, that we could trade notes, we can connect the dots, we can be more coordinated in our actions. This is, in fact, the first time I've met Amy in person. And as you can see, a lot of the work is parallel to one another. And that if only we could, coordinate further, it could put perhaps more pressure and highlight these issues. And of course, it's not only, as I said early on, where what you can't achieve by legislation, you can achieve by litigation. It's really the two working hand in hand. And it's a multidisciplinary approach that I don't necessarily have an answer to, except that we do need to find ways to pull together. I found that there are often these great efforts that are going on, and if they were only further coordinated, yes, there's a lot to be said for it developing in an organic fashion, but there's also a lot to be said for it happening in a concerted fashion. And so we have other tools here that we, as a firm, are exploring further in terms of not only using false and deceptive advertising as a tool, which cuts through a lot of the science and the delay that we often see in other forms of litigation. We don't necessarily bring these cases on behalf of folks who have physical injury, even though that is indeed the larger policy objective, the public health objective, but for economic injury. And for that reason, we were able to get a jump. The Wendy's case, to bring it full circle, for instance, happened over a decade ago. This was before, for instance, New York City or LA outlawed any use of trans fat in restaurants. This was a decade before the FDA has finally said this is unsafe for human consumption and is out of supermarket shelves and the like. This is a very effective tool to put pressure on the issue today. The science is there. It's unfortunately politicized around glyphosate. We often have these battles, and we have to wait for the science to work itself out, for the laws to work itself out. But this type of litigation that I've described to you this afternoon is an effective way to get a jump, to get ahead of the issue. But there are indeed other tools that other organizations have been successful in using. We have started to be retained by progressive companies in the meat context in terms of addressing anti-competitive behavior. And that's also a very interesting development where companies are starting to step forward, good, honest companies, against other companies that are cutting corners. And there are, other aspects of the law that can be further developed. We hear a lot about whistleblower actions, and there are ways in which, believe it or not, even school districts can step forward to address these issues, these food issues. And there are associations as well, trade associations that are popping up, such as the Plant-Based Food Association, which is a collection of a lot of vegan companies and the like. And trade associations also have standing under the Lanham Act. And so the point of the matter is that it does indeed take a village, and we just need to pull together and work together, hopefully.
Great, thank you, Kim. And then last, we're going to hear from Paula. Paula, do you have a presentation?
So I'm Paula Dinerstein. I am on the board of Beyond Pesticides, and my day job is I'm a lawyer for a group called Public Employees for Environmental Responsibility, or PEER for short. And my presentation is going to be a little bit different approach. I'm not going to talk about particular cases very much, but more about how we can use can you hear me now?
The mic's not broadcasting your voice. You still have to speak loudly. It's going.
Oh, okay. All right. So I'm going to be talking more about, can you hear now?
She's not mic'd.
Okay. All right. So I'm going to talk more about how we can use public employees to further our goals. And our organization is sort of unique in being among environmental organizations in that we are a service organization for public employees. And we bring litigation both offensively, what we call offense is when an employee comes, tells us about a problem, and we file an environmental suit about that. Defensively, we're talking about like if an employee gets in trouble for speaking out, then we bring whistleblower litigation to defend that employee. And we also do a lot of work, as you do, with the Freedom of Information Act, which I will describe in a little more detail. So we've been around for more than 20 years, and whether the administration is Democratic or Republican, federal or state level, unfortunately, there has always been, and we've always had plenty of work, regarding poor implementation and enforcement of environmental laws and programs and suppression of science. But what is new with the Trump administration is we have some new things to deal with. One of them is reductions in force, where the Trump budget has proposed cutting out literally zeroing out dozens of programs at EPA and other environmental agencies. And along with that, of course, hundreds or thousands of employees possibly will have to be let go. Outsourcing is where this move to have the private sector do everything that the government used to do. And gag orders, we've already seen that with, for instance, taking down government agency Twitter sites, changing materials on government websites, and also we've seen both on the federal and the state level employees being directed not to talk about certain subjects, whether it's climate change or something else. So the gag orders. So what we do is we use government employees and former government employees to inform our work. We like to work with retirees because they're not in danger of getting in trouble for speaking out anymore. They can say whatever they want. And yet they know the programs that many of them may have worked on for decades. They know them inside out. They know what the problems are. They know what the politics are. And they can be our guides. And they can also be credible spokespeople because they worked in those programs, either to defend that program from the budget acts and talk about what it actually did and how it benefited society, or also talk about needed improvements in the program. Now, we also use public current employees, their insider information, to fuel legal challenges. Sometimes in cases brought by our organization, sometimes we feed it to other environmental groups who are bringing litigation. So for instance, if you're challenging something, saying that an environmental impact statement was needed because there were significant impacts or there were impacts on endangered species, and we happen to know, because they have come to us, that the scientists in that agency themselves, had internal emails saying, hey, this is going to impact endangered species, that's going to be very useful for the people who are bringing a case about that. We also use current employees to spark scandals and investigations by deploying their information and exposing schemes unready for scrutiny. And what I mean by that is things that an agency may be planning to do, but they haven't really got their ducks together to be able to defend it yet. And if you put it out in the public before they're ready, sometimes they're forced back. And a recent example of that, although Pierre was not involved in it, is when the Trump transition folks went into the Department of Energy and they said, give us the names of everybody who has worked on climate change. And once that got out in the press, they pulled it back and said, oh, that was just some lower level person who didn't know what they were doing. So even this administration can be embarrassed and can be forced to pull back on some things. So as I said, we use the Freedom of Information Act a lot. Because the way we work is with insiders, most of the time, or all of the time, our FOIA requests are based on tips from people for what to look for. Sometimes we even already have the documents, excuse me, but we want to get them through FOIA, both to protect the person who's telling us about it and also so that the agency has to own up to, this is what we have and we're putting it out publicly. We use the media, sometimes even when we file a case, even if we haven't gotten any documents yet, we can use the media to say, hey, this agency is holding back. We asked for all their documents about chlorpyrifos or something, and they wouldn't give it to us. They must have something to hide. And then when we actually get the documents, then we'll go to the media again. So the way we try to work is we advise employees to be what we call anonymous activists. We would rather that they not be public whistleblowers. We want them to stay undercover, stay out of trouble, let us bring the lawsuits, let us go to the media, and you stay safe. You're the kind of employee we want to keep at that agency. Sometimes employees think, or the public thinks, that if you declare yourself a whistleblower, it's sort of like putting on a suit of armor. I'm a whistleblower, you can't touch me. Unfortunately, that's not the reality. What being a whistleblower can do for you is it's a defense to a personnel action. So you get fired and you defend yourself by saying, I was fired because I was a whistleblower. And then what a whistleblower case turns out to be about is, was this person fired because they were a whistleblower, or were they fired because they were a bad employee? And the real underlying environmental issue that the person was willing to risk their career for never gets addressed within the context of whistleblower litigation. And so we consider that some of our best work is talking down jumpers. But we also do have to be prepared to do whistleblower litigation, because you can't even ask somebody to be an anonymous activist if you're not prepared to defend them if it doesn't go right and they do get in trouble. So when we do bring whistleblower litigation, even though, as I said, within the context of the case, you're not addressing the environmental issue underlying it, we try to use it by going to the media. It's a public proceeding. We can talk about it and try to get the underlying environmental issue out that way. Sometimes our clients are actually reporting crimes, environmental crimes, and maybe they're going to like the FBI or a state prosecutor or attorney general, and we try to help them shepherd through that kind of proceeding. So one of our specialties is protecting scientists, but there are additional obstacles in protecting scientists even beyond your normal whistleblower, because scientists are usually not whistleblowers in terms of legal protection as a whistleblower, because what they have done is they've done science that their management or industry doesn't like the results that they got by doing science. And so they have not qualified as a whistleblower in terms of disclosing some illegality or threat to public health and safety. They've just done science. The other thing is that sometimes the way that they are retaliated against is not a personnel action you can challenge, like they're not fired or demoted or something, but the agency interferes with their ability to publish or their ability to, say, go to conferences and present their scientific results. And I think most scientists would be able to say very quickly that that is death to a scientific career. So, and the other thing is that the scientific integrity policies that all the federal agencies that had a lot of science put out during the Obama administration are basically toothless. But we have been able to use them. One, when we file a scientific integrity complaint, it exposes the issue. And secondly, it sort of bootstraps the person into whistleblower protection, because now they filed a complaint that their agency violated a regulation, namely their own scientific integrity policy, and that makes them into a whistleblower. So this administration is unprecedented in a lot of ways and very scary, but it's not completely unprecedented. And to some extent, we've been to this rodeo before. So during the Bush administration, we did have some successes, particularly working with EPA employees. We stopped the Cheers study. Some of you may remember that, where EPA sponsored a study where low-income parents were paid to continually expose their children to pesticides in the home for a 2-year period, and then film them to see if they were developing normally. So as soon as that got out in the press, it was stopped, and it was eventually completely withdrawn, with the help of Congress in that case. We got the EPA also to finally do a program to protect people in buildings with lead paint during renovations and repairs. And we also worked with the EPA unions to stop EPA library closures. That was one of the things the Bush administration was trying to close, and did close a lot of the EPA technical libraries. They were literally throwing out scientific articles, and we worked with the unions, got a lot of publicity, and again, in that case, with the help of Congress, they were ordered to stop doing that and restore the libraries. So getting back to what I said at the beginning about the agency cuts in the budget, do we have a way to fight that? Well, you can't really fight an agency from laying off people if there's no money appropriated for what they're doing. However, what we're planning to do is, one, before it happens, to deploy the expertise of these insiders about their programs, in that they can give a lot of detail about what their programs actually do and the benefits of them. And the Trump administration has asked people to file comments on what regulations should be abolished, and what, how government can be shrunk. And they say, oh, public, help us with this wonderful task. And so far, most of the comments have been, don't abolish these programs. But obviously they'll be stronger if they're informed by detailed information about those programs. So that's one of the things we're planning on doing. And then when they do actually get around to cutting people, although you can't challenge the overarching thing of, we have to cut people because we don't have money for them, the way it works is that they have to cut people one by one when they do a reduction in force. And every single person has to be justified as to they were cut versus somebody else based on their seniority, based on their performance evaluations, based on whether they have veterans preference and things like that. So it's a very bureaucratic, complex process, and we know this administration hasn't been that good at dotting all their I's and crossing all their T's, and so we anticipate that there will be a lot of situations that we can challenge the way they're doing it and hopefully gum up the works. So finally, we have, we estimate that there's like 250,000 public health and environmental specialists in government, and their expertise is much underutilized in the kind of work we do. More and more of them are being prevented from doing their jobs properly or possibly at all. And, we need to work to help them and also have their information help us.
If you guys can move the tables back together now, and we can turn off slide. So as we get set up, we're going to open everything up for questions. I will come around, so if you have a question, please just raise your hand, and I will bring you the microphone so that you can, sure, Amy's going to put up her last slide. And the panel, if you can speak into the microphone as well, you guys can have this one, just pass it down the table. Great, we'll let Amy put up her last slide, and then Melinda, absolutely, you can get us started with the first question.
So I have two questions, actually. The first has to do with class action lawsuits. And with regard to feeling like my body has been contaminated, as well as so many people, is there an opportunity for a class action lawsuit based on personal trespass? That's number one. And number two has to do with my own professional association, which is the Academy of Nutrition and Dietetics, which has been infiltrated certainly by big food. But more recently, we have been infiltrated by Monsanto, soon to be Monsanto and Bayer, doing webinars for continuing education in which, genetically engineered foods are promoted for all these, glowing reasons like feeding the world, et cetera, but evading the issue of increasing herbicides when our professional ethics requires us to act in the best interests for public health and safety first and foremost. So the second question has to do with an ethics violation for a professional organization, and the first is more of can we do a class action lawsuit based on personal trespass, toxic trespass?
With regards to your first question, that's a great idea. And I'll be more than happy to look further into that issue. Yes. And so when you also think about the fact that it's Monsanto that produces the majority of glyphosate, you don't necessarily have causation issues as to which Roundup is in my system. Exactly. And when you think about the fact that 90% of us are showing levels of glyphosate, it's disturbing. We in fact tested our two children, and we are pretty aggressive in terms of having them eat organic, and still they had certain levels of glyphosate, which is disturbing. With regards to your second question, there was a very interesting New York Times article addressing this issue, that there was this bill of goods that was sold that GMOs would save world hunger, it would increase yield, and that it would reduce the amount of pesticides used. Information that we are all well aware of is false and not true. And so there was a lot of chatter within the legal community as to whether or not there is a basis for lawsuit, and it is an ongoing investigation with regards to whether or not there is a basis to do so. Say on behalf of, in fact, GMO farmers who were sold this bill of goods, only to find that yield is not increasing, perhaps has decreased, and that they've had to pay increasing costs for herbicides.
Thank you to all the panelists for sharing your work and for Rosemary for sharing your story. I really appreciate it. This question may be more towards Amy, but in relation to kind of what Rosemary's experiencing as well. Do you think that recent publications such as the Lundgren paper on contaminated pollinator barrier strips on organic properties that are adjacent to corn operations and through coated seeds, do you think that will play any into EPA addressing this issue of coated seeds and or potential trespassing issues with pesticide contamination and organic standards and compromising someone's organic operation?
I mean, I definitely would hope that EPA would take that into account. So the standard, for actually registering a pesticide, right, is that it won't have those unreasonable adverse effects. And so if you add to that, well, okay, what are one of the adverse effects? Well, pollinators getting harmed and then actually hurting organic operations as well. I mean, that's you could really easily tie that to the economic impacts. And so EPA is supposed to take that into account. And so our petition to EPA is to actually even register in the beginning those coated seeds, but it does, it certainly would highlight, and we, included in that petition lots of the recent research. That would certainly highlight the risks to it. And, how that affects organic operations, like we just heard about, the inability to be certified. Once an operation's already certified and they get contaminated, then it is sort of it's not necessarily an automatic decertification or anything like that. It really depends that, it sort of triggers investigation of how that contamination got there and whether it was intentional. But yeah, I would just say that, definitely hurting organic should be considered an economic and environmental cost of those pesticides. So that's a really good way to tie it together, and thank you for that. Does anyone have anything to add? Yeah.
I was at the National Organic Standards Board meeting last week, and one of the things that came up after I had given my little public talk was that there was a farmer who had pesticides found on his property, and the certifying agency basically said, don't worry about it. And he went back and demanded that they take his license. And the reason is that people who really believe in organic want to stand by the integrity of that label. And we had a similar experience many years ago when we first tried to get certified. We had the agent come out from the Department of Agriculture, and he said, I said something about, my neighbor does spray, and he goes, we expect some drift. And I was horrified, and I looked at him and I said, the consumer doesn't. So I think that that's really the crux of it, is that you can get away with it if you are kind of sleazy, but if you really believe in the integrity of that label, then you will stand by it.
So impressed and grateful for the work that you all do. Thank you so much. And Rosemary, your story really affected me, and I think it probably affected a lot of people in this room. And I'd just like to ask everyone to just put your hand up in solidarity for Rosemary.
Great, thank you.
I was just thinking about Melinda's question, and there certainly is reason to question what Monsanto is teaching with these continuing education on it not being defensible scientific. But I'm also wondering, her organization has to approve these. Is there a way she could somehow force her organization to be more responsible in evaluating the scientific integrity of these continuing education programs? Just a question.
lot of money coming into the foundation from industrial ag, and it's. You want to use the mic? Oh, sure. So there's money coming in, of course, to the association foundation, but I go back to the ethics of what we're supposed to be a science-based. Everything has to be science-based, of course, but it's relying on industry science too to show the value of these crops. But it's the ethics that concerns me the most. You know, my responsibility is for the safety and health of the public, first and foremost. And that's where I see the violation, and I really would love to take them to court for that. Because it's my name and my RD means something to me, just like organic certification means something to the organic farmer. It's what we've invested our lives and careers in, our education. And losing that is a great loss in terms of public trust.
I mean, I wish I could. It's out of my wheelhouse personally. We typically are involved in, that big high level federal litigation, but it certainly seems like something that's, maybe grassroots level is where to start. I mean, are there other members of the association who agree with you? Can you form a block that's, gonna sort of try to appeal to the powers that be within the organization, and media maybe get some attention?
Yes, that too is actually done as well.
So I'll pass it to this man.
I also heard recently that the Center for Science and the Public Interest has been very effective in putting pressure. I believe that PubMed may ultimately have to disclose funding of research. And
CSPI is an interesting organization in that they really don't they've taken a strong stand on big food, but I don't see them being as assertive as they should with regard to GMOs and what they really mean. But U.S. Right to Know has been probably the best in terms of, I've sent information to U.S. Right to Know.
right, big shout out for U.S. Right to Know, and namely Carrie Gillum,
Correct.
who is just wonderful when it comes to just putting pressure and using the FOIA request and being persistent. And it was really because of her, for instance, that the government had to release information regarding glyphosate levels in honey and other documents between the EPA and Monsanto, which are just terribly disturbing. I don't know if it's outright in violation of any laws, but it's a very cozy relationship. There was a PowerPoint slide showing the two in bed, and it's very much the case where, as a result of Carrie Gillum's work, we've seen emails back and forth, sign-in lists that are supposed to be public meetings in which it's all EPA and Monsanto email addresses there on the sign-in sheet. Very cozy emails back and forth. And what was also disturbing was the discussions regarding some of my nonprofit clients being referenced. And for instance, Monsanto saying, by the way, Moms Across America will be at your doorstep tomorrow, petitioning. And so, but Carrie Gillum is wonderful at U.S. Right to Know.
And there's a new book. She's got a new book out.
Yes, yes.
I was just,
You mentioned this morning, Amy, that we have a precautionary system on one item on the product. Oh, explain that. What does that mean? Precautionary.
oh, so I was,
And compared to what they do in Europe.
Well, so I was mentioning the precautionary approach that is built into FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act, which is our pesticide law for the federal government. And the reason I call it a precautionary principle there is because that statute requires pre-market approval of pesticides. So you cannot sell a pesticide legally until EPA has approved it for sale. And that includes, the burden to try to show the safety standard. Registered or approved. Okay, registered for sale. That it meets the, that it meets the safety standard, that it doesn't have an unreasonable adverse effect on the environment, and that it has the correct labeling. Now, of course, we would argue that many of the pesticides that are registered do have unreasonable adverse effects on the environment, and so that's part of why I was explaining in our struggles in these cases to challenge new approvals, to try to get at old approvals, to try to cancel and suspend pesticides, and we've been doing a lot of that work. But so that's sort of the, since it's a pre-market approach, it's precautionary. We don't take that approach to a lot of our other chemicals that go out in different, consumer products. And it's more, okay, use it out on the market. Like BPA is a good example. Go ahead, use it till somebody decides that it's actually unsafe, and then we'll try to maybe get it off the market. And I think Europe's approach is different in that they're more precautionary in all of those senses. And they say, well, we won't use this pesticide until we know that it's actually safe. And while we do have this pre-market approval in FIFRA, in our pesticide law, EPA is still approving things that I don't believe were really were proven to be safe. So maybe my calling it the precautionary principle wasn't totally accurate in that. So I don't know if that answers your question, but.
The word that you use, precautionary, is not written in the law or in the regulation.
No, I don't believe they actually use the term precautionary principle in the law itself.
Okay, thank you.
So I think a big difference in the way precautionary is used and the way you used it, in the sense that things have to be approved before they go on the market instead of proved false, proved harmful afterwards. But I think a big difference between that and the way the precautionary principle is used in Europe is how uncertainty is dealt with. Because EPA tends to deal with uncertainty like, well, if we're uncertain that it's causing harm, then we're going to leave it on the market. While the precautionary principle in Europe is more to say that if we have uncertainty, we should err on the side of safety and precaution.
I agree with that.
Hi, how are you? My question is for Paula. You mentioned that it's important that employees must remain anonymous throughout the entire process. So my question is, when trying to put together a case against an agency or company, how does an employee reach out to you or your company? And are there instances in which peer reaches out to employees discreetly to build a case against the company?
Okay. I mean, it's not a hard and fast rule that they always have to be anonymous, but, it's something that we prefer for the reasons I said, to keep them safe. As an ethical matter, as a whistleblower organization, we don't reach out to people. They have to come to us because we don't want to be perceived as encouraging people to blow the whistle or to speak against their employer or anything like that. So everybody has to come to us. They find out about us, you just by Googling whistleblower. We have a website where people can put in a form, and then we promise to get back to them. And, we've never had a shortage of clients besides the fact that we don't go out and recruit. We do things like recently we've been going out and giving our executive director has been giving speeches to the EPA unions to talk about generally what their rights are and what their rights aren't, and with the free speech and sort of what's going on with this administration. So we do those general kind of educational things, but we don't recruit people specifically.
From a cynic who works for the EPA, I have heard that when a job opening comes up, the industry will find somebody that is maybe somewhat sort of qualified, write their resume, put in all the recommendations and do everything they can to get them in there so that they can stymie any progress on whatever the specific issue is. Have you ever run across anything like that? Is that being totally cynical and are those the people that are going to keep their jobs?
I haven't specifically heard about that. Certainly every administration tries to recruit like-minded people. There are, in federal hiring, there's a lot of rules and bureaucracy as to how they have to put out the notice and how they have to rate people, and HR departments do it. I mean, we've had several clients who have said, well, I'm being blackballed. And even though you might tend to believe that, it's really, really hard to prove. It was really hard to even convince me that it was true, given, the way the hiring process goes.
I just want to thank you all for all of your knowledge and sharing it with all of us. In 43 states, there's preemption where local communities cannot ban pesticides. They can't use the home rule. And I'm aware of, it's in a documentary, Toxic Chemicals, Kids in Danger. It was a French film that just came out in 2016. Hawaii is not one of those preemptive states. And I can't give you the specifics, but there is, I think it's 5 of the major chemical companies who are using these lands in Hawaii to develop the seeds. And the local people, I believe it was Maui, who came up and they decided that they were going to stop this. And they did in the courts. But then what happened is, I'm not sure what organization it was, what company, but they sued, and then the local people lost. And I'm just wondering, in terms of, if you aren't preempted, why do these companies have the power? I know that the focus was that who has the right to regulate pesticides, and I think that's really a big issue. They were saying, we aren't saying it's bad or good, we're just saying that in this case, we don't believe the people have the right to do this.
Right. Well, I think you're referring to the ban on growing genetically engineered crops in Maui and then Kauai and the Big Island as well. So actually, Center for Food Safety was very involved in trying to, and we have an office in Hawaii, trying to support and then defend those ordinances, because Hawaii is, as you said, a place where a lot of these companies, because of their long growing season, use lands there to develop GE seeds, and then they spray tons of different types of pesticides on them, and right near schools. And so it's a huge problem of pesticide exposure for children and people there. And so those counties were trying to get at that problem by saying, hey, don't grow your GE crops here, because we know you're growing them and developing them for use with pesticides. And unfortunately, it was Syngenta and other companies that challenged those in court. And we got 3 different rulings from 3 different district cases on sort of a spectrum of how preempted they were, both from the federal level law, which is the Plant Protection Act that the USDA administers with regard to genetically engineered crops, and then at the state level. And it all went up to the Ninth Circuit Court of Appeals, and that decision came down last year. And so the good parts of that decision said that federally, states and local governments are not preempted from regulating or outright prohibiting GE crops. So that's great. The bad part was that under Hawaii state law, that they were not allowed, counties in Hawaii weren't allowed to ban these plants because of existing sort of general noxious weed statutes. So it didn't actually say that they couldn't regulate pesticides. It said that they couldn't regulate GE crops, because that's what the different bans were trying to do. And it was based on, again, like these general, dangerous plant statutes. So I believe there are efforts in the legislature right now in Hawaii to try to get some better protections for, on the pesticide drift issue. As you bring up. So there's still hope as another way for Hawaiians to be able to protect themselves from this really unfortunate amount of spraying that goes on.
Couldn't have asked for a better person to be in the room for that question. Thank you everyone for your really thoughtful questions. I'm going to close by kind of posing 2 closing, kind of thoughts or questions to the panel, and ask them to each kind of speak to that, maybe just go down the line. But it kind of stems from something that Kim said during his presentation. And I think in closing, I would love to know, and I'm sure everyone in the audience would as well, for those of us who work in the environmental field, how can we come together and what can we do to work better together on these issues? And for those of us that maybe don't work in environmental issues but really care about this, what can we do as individuals to, try to effectuate change on a daily basis when it comes to these kind of issues? So as a profession, as a collective group of, organizers and lawyers and journalists and everybody who's working on this, and then also just individually, what could people do? What could you tell people in your community to do if they want to make a difference?
I'm happy to start. I think from the first part is how as we as a movement can we come together, if you want to call it the food movement, but the broader, environmental movement, social justice movements that are all totally integrated. How can we actually become more integrated and be more powerful? And I think it's a lack of information about what everybody else is doing is part of it, which is crazy that in the age of information, we may have trouble sharing that. And as an attorney, I am definitely one to say, don't always write it down. We should meet in person. I mean, maybe just big, broader coalitions that, there's coalitions on certain issues, factory farming, genetically engineered crops, pesticides, obviously. But, we all need to meet together. Maybe it's a massive conference every year. We got to leverage the fact that maybe that's what it is. I don't know who's going to organize it. Maybe you. I think I vote Annie that you start the human movement, you can name it whatever you want, that's my pitch, to actually leverage our ability to communicate with each other nationwide and worldwide, because we have this amazing ability to do that. We just need to share sort of what everybody's doing and, split up the tasks accordingly and really try to prioritize. And one of the things that I always see is how industry and how, other sectors like labor can be so effective, especially like our state level in Oregon, is they come out with this list of here's the top 3 priorities we have this year. Everybody gets together. Here's what we're working on in the legislature, and that's how we're going to get done. And I think we need something like that. And it's going to be hard to agree on, but what are our top priorities for this year or this next 7 years or whatever it is. So yeah, I mean, I would be happy to do that. We work with coalitions, CFS, all the time, but they're littler coalitions. They're maybe state-based or they're issue-based, and we need a big one. As to the second part, I have a little bit of what people can do up here. Buy organic food is one of my suggestions. Consumer demand obviously is super important. That's going to change what happens. So that's something anybody can do. You can demand it from companies, even if you don't buy their products. You don't have to tell them that. You can just demand that they change. And then join all the NGOs. And that is a selfless plug for a shameless plug for Center for Food Safety, but also all of the other wonderful organizations here today, because again, we can get all that information. Action alerts, what are they up to? Where are the comment opportunities? When is it time to yell at EPA about what they're doing or any other federal agency, or time to call your legislator at a state, local, federal level, tell them what they should support and not support. It's easy to click those petitions and it's easy to make a call, but you'd be surprised, maybe some of you would be surprised because you're probably pretty active people, how few people will actually just get on the phone and make a phone call to their elected representatives. So do that. And then, focus on the local level. Everyone's been saying that, but that remains true. We have a lot more power. You can win something by 9 votes, was it? You have, your vote may count a lot more, and you can run for office, as was mentioned at lunch today. And finally, I'm going to say resist. I know that's what people are saying right now a lot, but we have to vote. You have to vote. Vote people out who are doing a bad job in leading us, and I will pass the mic.
I just want to echo all of Amy's comments. This question actually was posed at NYU recently to Mary Nessel, who wrote Food Politics, about the future of the food movement, and was commenting on the fragmentation we see, between various NGOs and different organizations. And, she said that there are certain factors that unfortunately divide us, but at the same time, she believes in this ecosystem that has developed between the various organizations, and feels that it is healthy in some respects to not always be as one, but to have multiple voices on multiple fronts. And so that resonated with me to some extent. Nonetheless, I would like to see more coordination along the lines of what Amy outlined.